time to take a deep dive with Judge Bledsoe in North Carolina on the FSU motion to dismiss, stay, and the ESPN motion to seal.
These ACC lawsuits are always in the news, so we're back on the big mountain to break it down for you.
Hey, welcome back to the mountain, but if you're new here, we especially welcome you. I am JY. This is my good friend Steve. We have been doing all things ACC and FSU ever since the very beginning of these lawsuits, and we finally had our first hearing. Steve, we did a breaking episode last Friday on the hearing in North Carolina with Judge Bledsoe on the motions to dismiss and stay, and also on the motion to seal by ESPN. We said in that episode we were going to be doing a deeper dive with that, and here it is a week later. I want to start off by just reminding everybody, we are not lawyers. We don't claim to be lawyers. However, we both do have business degrees. We go through some of this contract type of situations in our everyday lives, if you will. And we just want to provide our opinions on what we've heard. Both Steve and I listened to all 3 hours of this hearing. And we want to just give our opinions under the purview that we have, and you can take them or leave them. And to be clear, we have no skin in this game. We're not ACC fans or FSU fans.
Yes, I agree, JY. And I will add, both of us, our day jobs kind of put us in a position where we're kind of at the intersection where education and business and kind of small level government all meet. So we definitely have some perspective on this, although neither one of us has gone to law school or passed the bar exam. So.
No, I haven't done that. No, I haven't done. I've passed some exams, but not the bar exam. Hey, I want to just mention before we get into the nitty of this, I did listen to a reaction from the Renegade report, and I bring this up because I had used on our last reporting the tweets from Doug Rohan, and he's where I kind of got all my information from. I know you were watching a couple of them, but that night, on Friday night, he actually was on to give his opinions for about a 10-minute segment. So I just want to give a quick shout out to the Renegade Report, especially Jen Santee, who's one of the mainstays on that. And I'm going to give her some credit. They're an FSU channel, the Renegade Report. That's what they do. They're very, very, I'll call them Seminole homers, if you will, is what we call. But I'm going to give her a lot of credit, especially Jen, because she was skeptical on a lot of this. It was good to hear that, I think she was trying to keep an open mind. Obviously, she is sided with FSU. And I believe we've gotten a few comments from her as well on some of our past episodes. So maybe eventually we could get Jen on here if she'd be interested. But anyway, we can talk about that at another time. Overall, I think Doug, did a good job of putting out tweets on this. I will say now that I've heard everything, certainly a little skewed towards the Seminole side of things, which is fine. I get it. He's a Seminole fan. You're going to have that. It's hard to be completely unbiased if you do have skin in the game.
He's not as biased as the one Duke alum lawyer that I was following along with, that every word and everything and every sigh by the judge or whatever was an obvious take on the ACC's position, and how FSU's position was just ridiculous and absurd. So
interesting. And I will say I enjoyed. It's good to actually hear the hearing, but I got just as much enjoyment out of the back and forth and the nonverbals or even laughter from the judge and just the interaction. Really good to see Judge Bledsoe here. We were big fans of Judge Levy.
Yeah.
I think I'm going to be a big fan of this judge as well. He seemed very personable, very interested in that interaction.
And experienced in, there isn't a lot of cases like this, but he's a business court judge. Right. So this is his wheelhouse.
So at the end of this, I want to give our conclusions on the hearing, and I'm going to even give what I think how the judge is going to rule. I'll let it up to you if you want to do that or not. I'm going to be pretty definitive on probably 4 of the 5 issues that we're going to raise, which were the main issues of this hearing. But let's get into it. The Judge Bledsoe opens with a statement just saying that these are very fine lawyers. They've done an excellent job setting forth their positions in their briefs and whatnot. And he had a lot of questions and engagement, back and forth discussions with the lawyers, which I really appreciated. I'm also going to talk about some of the nonverbals here with head shakes and things like that you could see. But let's start we're going to just go through this as the hearing went. So it started with Attorney King on behalf of FSU. So they took about an hour with FSU, and then we'll get into about an hour with Cooney for the ACC, and then we'll get to the Stay ESPN stuff here towards the end. But the opening statements here by King were about the true plaintiff should get to choose the forum, and in order to be the plaintiff, you have to play by certain rules of the game. And he defined those rules of the game to be twofold. Number one, the ACC Constitution and bylaws that the members have agreed to. And number two, the rules governing civil litigation, which includes the U.S. Constitution and case law. And we'll get into some of those cases here in a bit. He stated that the ACC did not follow its own rules surrounding its constitution and filed suit before it was ripe as defined by the U.S. Constitution. It filed in a court that lacks personal jurisdiction over FSU, a sovereign entity in the state of Florida, and he focused on the first filing, and as he called it, and he said this a lot in the beginning.
To the courthouse.
Yes, the race to the courthouse. He said it a good maybe, 5 to 10 times in the first maybe 10 minutes of this sucker. I said, I think we got it. You think it was a race to the courthouse. But be that as it may, he definitely got that point across. He stated that this declaratory action, and you know what's funny? I just said declaratory, and I actually heard King use the word and he stopped. He had to catch himself, so I'm not the only one. No. Attorneys do it. Yeah. But declaratory action was about the grant of rights and the 2036 expiration and the media rights associated with these contracts that is worth over $100 million. He stated that this is clearly material litigation. He then wanted to address three main arguments, that of standing, sovereign immunity, and ripeness. And again, I'm going to give my conclusion, my opinion on those three items at the end of this episode, where I think the judge is going to be. And again, that's just JY's opinion. You can chime in if you like on your opinion. He started with the strongest argument. We've talked about that before. Typically attorneys like to kind of start with their strongest and then get kind of to their weaker. That's clearly what King and FSU did here. The standing argument is their strongest, and then it's the sovereign immunity, and then, in my opinion, the ripeness is their weakest. I don't know if they laid them out in that order because of that, but certainly from my opinion, that's what they did. So let's go into standing. Again, the most obvious argument. King stated, we did not know that the ACC did not have standing when they filed this motion to dismiss. The judge then questioned, and you're going to hear a lot of back and forth. I'll say the judge said this and King or the attorney said this. I think it's important to hear some of this interaction, and I think this was an important one. The judge questioned if there was no standing for the first action, which would then create a nullity under North Carolina law, meaning that action is null. You can't bring it. Why then would you, FSU, say that the amended action would create standing on January 17th, which was the second action by FSU, the amended action by FSU, as you did in your brief? How can it be revived if it's a nullity? Don't they have to refile, basically start over with this? King answered this with, yes, I think they would need to refile. But he talked in circles here a little bit. Like, you can't say, well, really the January 17th action is when they got standing, but then say, well, no, they would just have to refile. So I found that to be a little bit contradictory to what he was saying early on.
It was at the beginning, and I think I felt like he's a younger guy.
Yes, he looked from behind. We could only see him from behind.
And you hear his voice, and he definitely seemed nervous at the beginning.
Yes.
And he's a younger attorney, and I'm not sure if he's on the FSU their like normal regular legal team, or basically he's a board. He's a bar member in North Carolina, so they have to use him to appear. But he seemed a little nervous at the beginning, and he was a little murky on that. Now, later on, when they had the rebuttal, he clarified some stuff.
He did.
I'm not going to mention anything yet because I'm guessing you're going to get to it.
I will.
But he mentions he some other things to clarify that.
Yes. Hopefully I do. Again, we're going to lay this out kind of as it happened in the hearing, and if I don't, please come back to that.
He was definitely a little mushy-mouthed at the beginning and tentative and talking in circles, not super confident.
And which was honestly counter to Cooney for the ACC. I thought Cooney started out really strong when we get to him, and he kind of petered out at the end. But yeah, I'm with you. I think and maybe it was his youth. I don't know what it was, but I didn't think King hit the ground running super strong.
And the ACC attorney, I mean, I don't know, I'm not trying to pick on anyone, but he looked like he had maybe a couple decades on the Florida State attorney. And from what he said, he's been in that courtroom in front of that judge many, many, many times over the years.
Again, favorable.
Yes.
Court, if you will.
Right.
And not favorable, meaning the judge is going to lean one way or the other.
They've been there,
but there's relationships there. They know how each other operate, for sure. So the judge went on to question about the Gao case. And we're going to talk about this several times. This came up several times, especially about retroactive approval. So he asked, what about this Gao case? Wouldn't this allow for retroactive approval? Of course, King says, no, it would not. And that does not apply here because there was no question of subject matter jurisdiction. The difference here is that there is a competing action. So when he's saying that case doesn't apply as it does in this case for several reasons, and he gave those. Again, I think here early on, King struggled a bit. It didn't seem like the judge was fully buying his explanation of these couple items. He'll get into it here in a little bit. King will get better, but he struggled here out of the gate.
Yep.
King then goes on to say the January member vote was not to ratify the original filing. And we're going to talk about this several times. They talk about this a couple different times. But he says it wasn't to ratify the original filing. The vote was to approve the amended filing and the motions in the original filing. It was not a vote to litigate. All it did was approve the next steps for the ACC. King then brought up the fact that a vote was taken by the ACC members before action was taken in Maryland. Now, two different cases. I don't know if the timelines line up exactly the same, but I thought that was a strong point to say, hey, when this happened before, they took action, or they took a vote prior to taking action against Maryland. That wasn't the case here early on. Then he got into materiality. Materiality, to me, Steve, is one of the biggest issues of this case that the judge is going to have to rule on. We talked about that in our first episode.
So the first part was standing, correct? Or
standing, and then, standing, yes, and then materiality has to do with standing.
Okay, so
yes.
I want to just say something on the standing.
Go ahead. Yep.
As far as what King was arguing, and again, he gets a chance later to clarify.
Yeah.
Because I didn't really understand the point he was making at the beginning. It becomes a little more clear later, but I want to hit on it now.
Yep.
So the big difference in this is, basically FSU is arguing that the ACC didn't have standing because they hadn't taken the vote yet. Whereas, and you're going to get to this, the ACC lawyer is arguing that there's an injury. That's all they need for standing. There's an injury,
yes,
and they can ratify. If they didn't have the approval, they can ratify it later. Whereas King makes this point that when they did go back and do the vote later on January 9th, it wasn't to ratify the initial decision. It was to approve the new amended filing after things had happened. So I've been saying all along that I didn't think that whether they took the vote or not was going to end up being important.
Right.
Because I said it was easily remedied.
Yeah.
The judge was a little bit more open to this than I thought.
Yes.
And I really was confused on this until King clarified that the reason they believe so is because that January 9th vote was not a ratification of that early vote. There was nothing in the wording saying we're ratifying the initial decision.
Correct.
It was all about approving the new amended suit, which I think is huge. And I didn't fully understand that before, but watching it and hearing the arguments, it made more sense.
You're exactly right, but Cooney does counter that.
Yes, he does.
He does, and I'll get to that here as well, but very good point to bring up right now. So let's get to materiality, which is part of standing, because that gets into what is actually stated in the Constitution of the ACC. And again, I think this materiality is where King starts to get into it, starts to make some hay with the judge, make some really good points here. So the judge asks a question. The ACC is going to say, and a lot of what the judge did here early on was kind of say what the ACC's argument is, and he wanted him to respond to it. So it wasn't this another hour-long meeting where they had to respond to each other. He was making ACC points from their brief so that King could respond. So the judge says the ACC is going to say that the first filing was to maintain the status quo. There was not an action against a defendant. The amended filing required a vote because damage claims were made against FSU. Again, this is the ACC's argument, and we're going to get into that a little bit more. But then he goes on. Also, the action that was filed yesterday against Clemson, and the Clemson case comes up 2 different times. This is the first time that was filed against Clemson, did receive a vote by the ACC members before filing because it also included damages against Clemson. What do you say about the status quo argument? King's response to this: status quo is not materiality. You have to look at context. A preliminary injunction would require irreparable harm. Irreparable harm would have to have a material consequence.
Yep.
He went on to say that in order to better determine if this is material, we should go through discovery so that the court can better understand what is in these contracts. They get into a lot more with that in terms of the seal here in a while. Part 2, yes, for sure. The judge then goes on to further his questioning. Under North Carolina law, courts are not to interfere with the internal governance of a volunteer association. According to the ACC, that includes interpretation of their bylaws, and that their judgment in the fact that this first filing was not material is only upset if the court determines that their judgment was unreasonable or that if it was regarding a fraud. Mr. King, is that a correct conclusion? Mr. King says, no, it is not. The ACC has a constitution that is a contract, and that contract is between the members. It is up to the court to determine the plain meaning of the Constitution. This is all about the actual meaning of materiality. And Cooney gets into this more on his side of things, but that's what this is all about right now.
Agree, and I'll say there was more distinctions made in is it Cooney or Cooney?
I think it's Cooney.
Cooney. He's going to get more into this.
Yes.
There's another. So we talked about the other argument of having standing with the vote versus there's an injury. We have standing because we have an injury.
Correct.
No, you don't have standing because you didn't vote on it.
Right.
This one, in this area where they're arguing, they're citing the law that they're citing governs nonprofit organizations.
Yes.
And the judge says, there's been other cases that the ACC is citing where other judges have determined we shouldn't get involved in the internal operations, the bylaws. Mm-hmm. Whereas the FSU attorney is saying this isn't just like the internal operations of your HOA.
Yes.
This is the Constitution is a contract between the members, so it should be viewed differently than just an HOA bylaws or a booster organization bylaws, right, or something that we're familiar with. So I thought that was interesting.
It was.
That they're making those 2 separate points. And it goes back to how the judge is going to interpret North Carolina law based on these previous cases that happened in North Carolina.
Yes.
Both of them cited cases in North Carolina, and the judge multiple times cites decisions by the North Carolina Supreme Court.
Correct.
Which I thought was interesting. Yes. Please go ahead.
But you're right. I mean, that to me, that was the peak of the FSU argument. Started a little slow, hit their stride with the materiality. Now, when we get into sovereign immunity argument, they start coming down the backside of the mountain, for me anyway, and you can push back on that. But let's get into the sovereign immunity argument. The judge questions King here, is the state statute in Florida even relevant in the light of the Farmer versus Troy case with the U.S. Supreme Court? If there is a sue and be sued clause, which is in both North Carolina and Florida, and you have a business activity in the state, meaning a business activity in North Carolina here, then isn't this enough to overcome the Florida statute? The Troy case uses Alabama, which is actually even stricter than what Florida statutes actually say. King responds with, if FSU would have registered in North Carolina as an entity and agreed to sue and be sued here, then yes, that would apply. But that did not occur. The judge goes on and says, but did the Supreme Court list that as a requirement to be sued in North Carolina? King responds, the difference is between the 2 entities in this case and lack of registration by FSU in North Carolina. Troy was doing business in the state. That is not the case here, where FSU is just a member of an association. I do want to say the judge did take some notes after this kind of back and forth interaction. He was writing some things down, which to me means something was said by King. Furthering,
go back and look it up.
Yes, furthering his case. Expounding upon his brief. Some of that interaction, the judge really took notice to because he started to take some notes after that. So anything with sovereign immunity, and then I'm going to get into the ripeness.
Yeah. So we should do a clarification because I believe that was he was referencing a North Carolina Supreme Court.
The Farmer.
Case, the Farmer versus Troy. And
I may have messed that up.
I believe so, but we can get some clarification on that. Maybe one of our viewers can help us clarify.
It was
a
Supreme Court, whether it was state or United States. Yeah, I may have made a boo-boo.
Yeah, I'm pretty sure he said North Carolina Supreme Court, which again they were going back to how does this specific. There was 2 laws that deal with nonprofit organizations, and how have these been administered in the state of North Carolina? And so King was trying to make the point the difference between their case and with Troy is that FSU had not registered as a nonprofit organization that's doing business in the state of North Carolina.
Yes.
I don't fully understand the significance of it, but he made a big point of it, and the judge seemed to kind of, I need to look into that a little deeper. So I thought that must have been an important point.
I totally agree. Yep, there was something there that interested the judge.
Yes.
So let's get to the last one. To me, the weakest of the arguments that have been made, which is the ripeness argument. This ripeness is this whole, was there an actual controversy? We've talked about this on several episodes, but I'll go through a little Q&A with the judge. King started off with a statement that the NC Declaratory Judgment Act does not say that you can ask for a declaration before there's a breach, but there has to be an actual controversy in order for it to be ripe. The judge questions King here. The FSU argument is theoretical. I don't have any evidence in the record on which I can rely to show that the president or any member of the FSU board was uncertain that this vote was going to pass. Nothing suggests, as the ACC states, that this was not going to be a done deal come that board meeting. King responds, FSU has presented nothing in the record other than theoretical evidence. I'm just going to say here, that's tough because the judge was asking for more and he's like, nope, all you're getting is theoretical. And the judge pushed back on that, and there really wasn't a good answer other than, it's just theoretical at this point. They go on, and then I'll turn it over to you, Steve. The judge then questions, why should a Florida court hear this case since only 2 of 15 members reside there and that the grant of rights contract was entered into in the state of North Carolina? The ACC says these should be governed by North Carolina law. Why is that not correct, FSU? King says, he brings up sovereign immunity again. But again, the judge pushes back, and then King goes on and says, this is a huge concern for the state of Florida. Also, there are questions of Florida law, such as restraint of trade, and who has the authority to bind the state of Florida. Again, we're kind of to the end of this here. The judge pushed back on this piece pretty hard. There was a lot of back and forth here right at the end. He was really interrupting sometimes, not rudely interrupting, but really trying to get to a place that I don't think King was able to get to for him, but that was just my read on it.
Yeah, the judge was very pointed because on questions. I agree there. I think he's really trying to identify the differences in their position on this. As far as I want you to strongly, the ACC is strongly arguing why it should be in North Carolina, other than they got there first. They ran to the courthouse first.
Right.
So I want you to argue strongly and give me a definitive position as to why it should be in Florida instead of North Carolina. It was interesting. I don't think he wasn't as strong there as he was in some of the other parts.
For King, you mean?
Yes, King.
Agreed. I thought he started a bit weak. And by weak in the beginning, he was just not getting his footing very well. Yeah. I don't know if his arguments necessarily were weak, but he struggled to get his footing. Once he did, he did well, and then by the end, he kind of lost steam again. Again, I've said that before, but that's kind of where I was at with him.
And I think, and I was going to save this point for the end, but I'll touch on it briefly. I think the thing about this part in particular comes down to again, North Carolina law versus Florida law.
Yes.
You know, a judge in North Carolina with their specific laws and how those laws have been interpreted and enacted, not just enacted, but enforced.
Yeah.
May have a different perspective than a judge in the state of Florida. And, you know, the judge here was trying to get him to make those arguments as to why I should look at, you know, Florida laws more strongly than what I've already, you know, carried out in my courtroom, right, and the Supreme Court of North Carolina has already carried out there. And I'm not sure if there was a great answer for that other than, hey, we're a public university in Florida, which is gonna. He also, you mentioned about the race to the courthouse. He also talks multiple times. I think he mentioned here and a few other times that the ACC is made up of, I think, 9 public members in 7 different states.
Yes.
And I think he's trying to make that argument of, you know, if you just decide in North Carolina based on North Carolina law, how are you going to apply that to the laws of all of these different states? And they use that a little bit more in the motion to seal part, right, but I think he did bring that up briefly here.
He brought that up several times. I appreciate you saying that. And my take on that was more, you can agree or disagree, was more that this is going to be heard in North Carolina because of that. Like this is I was reading more that this is a North Carolina contract, so we have to rule, or I have to rule in North Carolina because it's a North Carolina contract. That was my takeaway from that. Or did you take something different?
I'll save my thoughts on that until the end, because there's some stuff with the motion to seal.
Yes, for sure. Well, let's get to Cooney then. This is the attorney on the behalf of the ACC. Opening statements here. He said this lawsuit is about integrity and accountability. I know our FSU fans are going to be like, it's funny he started with that because FSU could have started with that. But anyway, the ACC starts with that, about integrity and accountability. He started with the signature on the grant of rights and the warranties within the grant of rights. He also stated that the grant of rights is a North Carolina contract. Again, that came up a lot, like both from the judge and from the ACC. I felt like the judge was being like, yeah, this is a North Carolina. I mean, he didn't rule on that, but he kept saying that. So I don't know, but it's a North Carolina contract, and the ACC is a nonprofit association in North Carolina. You know, Cooney, again, to me, started with his strongest arguments, which is almost reverse of what the FSU arguments. You know, they started strong and ended weak. Well, the weak was Ripeness. So Cooney's going, well, I'm going right into Ripeness because I know that's your weakness and that's our strong point. And that's what he did. And I thought Cooney, conversely to King, I thought Cooney started really strong.
Yes.
100%. He started really strong. He died off towards the end, again, in my opinion, but I thought he started out fantastically. And we'll get into Ripeness.
I'll say again with Cooney, you could just tell he's an older attorney, very comfortable in that courtroom in front of that judge.
For sure.
Very comfortable with, especially that arguments. Made some great points and was just very confident in his own arguments, which got him. And, you know, he knew how to get the judge to laugh. You know, it was great. He, you know, kind of said, well, Judge, you've ruled against me a few other times, but I feel pretty good this time. You're going to rule for me. So, he was much more of a smooth customer, smooth operator, very comfortable.
And I'm not going to get into the Ripeness real deep here. There's some other parts that are much deeper for me with the ACC, but Cooney stated the case law is clear that a breach does not need to occur in order to bring a case. And in fact, we knew they were going to bring an action to breach the agreement based on the Board of Trustees meeting announcement, which stated an action to initiate litigation and challenge the validity of the grant of rights. The board did then approve an action to breach the contract, at least according to the ACC, to breach the contract. And he stated, case law about this point is clear. Clearly, this was ripe and breach was imminent. I'm done. I'm not going to go any further. I thought he made very strong points. You're going to hear my conclusion on this. I think you probably know where I'm at, given my opinions thus far. I also think this Ripeness is not a huge issue for the judge.
Yeah, and I think, if I remember correctly, that's the point where Cooney points out that the Florida State, their news service program, applicate website, whatever, had already, before the meeting even, had published what the lawsuit was going to look like, and basically the fact that it had already been approved So he was saying, any reasonable person would think this was a foregone conclusion because Florida State's own, FSU.edu
That's what he said.
listserv or news service was already basically saying it was a foregone conclusion.
They did it the evening before the Board of Trustees meeting. He did bring that up. Good point. Second point here is authority and standing. Now's when we start to get into a little bit more of the back and forth with the judge that I think was important. So he started out here and stated that in North Carolina law, standing goes to subject matter jurisdiction, and standing is a very broad term. The judge then asked a question saying, the ACC acknowledges that it had to follow its constitution to initiate a lawsuit, correct? Cooney says, yes, that is correct, and that is what we did. Question then comes up. So the ACC's argument is that it followed the Constitution of the ACC in determining that this was not a material litigation. And this is where we're getting, again, this was the strongest argument to me from King, and we're getting into this piece here now with Cooney. So the judge is asking about this materiality. Cooney says correct, or that there was ratification at the January meeting, which under Gal makes it material. At this point, you can see King visibly shaking his head no. Visibly.
Right, and he covers that later in his rebuttal, yeah.
The judge then goes on. So let's talk about the Gal case from the Supreme Court. It states that subsequent, again, North Carolina Supreme Court. I'm going with you.
I believe so.
It states that subsequent events cannot confer standing retroactively. Your argument, ACC, is to consider that portion of the ruling dicta, meaning just extra words that really are meaningless, quite frankly, and follow an older decision before that ruling. Cooney says it does, but not that it's dicta. And the judge says it's pretty directional that it's dicta. And there was some giggling there after that. Again, kind of that little ha-ha back and forth stuff.
Inside yes. Law school humor. Yeah.
For sure. There was some additional back and forth there for several other cases that got brought up. They're kind of talking about different case law. I'm not going to get into that here right now. And Cooney gave the court those cases to get around this Gal case stating that ratification, and then he stated that ratification is allowed across the country, was using these other courses and supporting the fact that some of the verbiage in Gal was just dicta and does not apply here. The judge then goes on to question him and says, so your legal proposition is that ratification is available if the injury in fact occurred at the time of the initial lawsuit. Cooney says correct, and then the judge says, did you argue that? Or did you argue it that way in your brief? And that's when Cooney goes, well, I believe I did, but maybe I didn't argue it that clearly that way. And we're going to get back to that a little bit because what the judge heard there was different than what he read or what he thought he read in the brief, and certainly not what King, because King gets asked about that on rebuttal, and certainly not what King thought the ACC was saying there. But I think through that interaction, I felt like Cooney made some hay with the judge.
I think so. However, he may have made some. We'll have to wait till his ruling to know for sure. He may have, but I do feel like that the judge was pinning him down on the ratification issue
for sure.
Basically saying, okay, what you're saying is, even though you didn't have that vote when you made the initial lawsuit, mm-hmm. when you first filed suit, mm-hmm. because you can fix that by ratifying it, mm-hmm. and you did that. You're saying you did that in January. Mm-hmm. I feel like he's really pinning him down to that, which becomes interesting then. And also, I'll save any further thoughts until after King's. If you're going to talk about King's rebuttal,
I am, but let's get to materiality first, all right, because really and it was in the answer that Cooney gave when he said, "Yeah, that's correct." In terms of materiality, but we also have ratification. Yeah. So materiality is their first argument. Ratification is kind of the backup to materiality. Yes. They got to ratification first, and then they got to materiality. Yes. Materiality is their first argument. So let's get into that. The judge asked a question, should I afford the ACC some deference in making a determination as to materiality? And as long as it's reasonable, then the judge, will not exert judicial review and impose my own definition of materiality. Cooney's response is yes, and let me add a few things. the ACC has a right to interpret its own bylaws, specifically here regarding materiality. The only way you can set aside the ACC's interpretation is if you think it was an arbitrary and capricious determination. So the judge says, so it is a question of judicial review of materiality. Cooney goes on, yes, but the courts typically stay out of these internal procedures. Your Honor only has to decide if it was a reasonable decision or not. Maintaining the status quo is different than taking action against a member for damages. The judge goes on, but losing the argument on status quo if the ACC's most valuable contracts are found unenforceable, how is that not material? I mean, we are getting to, my opinion, the biggest part of this whole issue. Cooney goes on to answer, the issue here is what are we initiating? It is not an issue of what we are going to lose. The judge then says, this is an odd provision. And he literally says, this provision of material judgment, he goes, this is really an odd provision. They have that little bit back and forth between two guys that certainly had been in court together before. He goes, this is an odd provision. And Cooney agrees and just says, it is, and it's not a defined term within the Constitution, and that is why you should defer to the ACC's interpretation. Really pushing the envelope there, but he said it. and the judge laughed after that.
Yes, and here's the thing. So, in where I think it's really hard to gauge those two, the ratification versus materiality. Yep. Cooney is very confident in that argument of the materiality.
Yes,
and he's basically saying, Judge, you don't want to get involved in determining if we were being reasonable with this, and interpreting our own bylaws and whatever, and our own Constitution. And the judge didn't really ask a lot of questions here. He was just kind of like you said, this is a weird provision, yada yada, and it led me back to when they were going through this. It led me back to that ratification point where the judge really seemed to be interested in that ratification and really pushed, and that's where Cooney was kind of. He got a little bit put in the spin cycle like King did early on. Right. So the judge got King in the spin cycle early, and he got Cooney in the spin cycle there at that point. And I think for both of them, it's kind of like it was their weaker arguments. So to me, I agree with you on the materiality. It seems pretty kind of easy and obvious. However, that question of the ratification, I think, is big, and the judge seemed very interested in that. And that's something, again, that I have been saying since the beginning. I didn't understand why it was such a big deal on FSU's point, and I didn't think it was going to be relevant at all. But the way the questions are, and then what King says on his rebuttal, I think kind of opens the door on that ratification issue.
But again, if the judge rules in favor, I don't say rules in favor, if he doesn't find the materiality argument here to matter, and he's going to rely upon the bylaws of a nonprofit association, and that they made a reasonable assumption or a conclusion, I should say, in terms of this, you don't even have to get to the ratification. The ratification is the backup to the ACC if they fail on materiality.
Well, that's their argument, right, the backup. But the other side's argument is that they didn't even have standing because they didn't approve it to begin with. So I don't know how the judge is going to go on this. He definitely, for whatever reason, and it goes against what I've been thinking all the time.
Yes,
he definitely was focused in on that ratification issue and asking a lot of pointed questions. But like you said, the Coney, he wants the argument to be about the materiality.
Absolutely. And
that's what he's really confident in, and he made great points as far as that argument.
And really good, again, more of a it was a Q&A, but it was also a discussion between them, too. So the last thing here before we get to sovereign immunity, Cooney then states, there was a process to try to figure out what it meant in the context of this skinny complaint. And that's what he was referring to as, or that's what he called the first filing, this skinny complaint, where there was only 2 claims for relief, both of which were declaratory. The ACC could have asked, and he took this a step forward, like, all we did was ask for relief of these 2 items. That's all we did. Again, materiality, that's all we were asking for. However, the ACC could have asked to seek affirmative relief or an injunction or some sort of TRO. And they didn't do that. He says that was a bridge too far for them in terms of this provision. So they asked the court to affirm the status quo and that FSU was stopped from challenging the contract. Again, just beefing up his whole materiality complaint. Whether or not the judge agrees, we don't know that. Yeah. But that's him beefing up that materiality issue. So let's get to sovereign immunity. Not too much here, but Cooney stated that the Farmer versus Troy fully applies in this case. So then, to the point you've been asking for, that's all I got on sovereign immunity. He just said, hey, it's ruled by Farmer Troy, done deal. There's not much. I mean, they had more conversation, but that's all you really need to know from that section. The judge then allowed King to respond to the ratification argument made by Cooney.
The new argument. He was still on that, wanted to go, and he asked him to respond to that first before he talks about anything else.
Well, he said, you can respond, but I want you to respond to this. And King goes, well, I'm going to respond to that first because I don't want to forget it. Yeah. So King responded, and that's going to be the main gist of what I talk about here in his response. King focused on the fact that a vote needed to be taken, not on materiality. I mean, his response was just like, they had to take a vote. Yeah. He really didn't bring up materiality in his counter. It was like, you had to take a vote for standing. King stated that the vote in January was not a ratification. It was to file an amended complaint. It went back to Cooney then, and Cooney responded to that saying the filings of the amended complaint included the complaints of the original complaint, which is ratification of the original complaint. Now, there was back and forth where King's like, and you mentioned this earlier, they didn't say they were ratifying. It was the vote wasn't to ratify. That's what King focused on. Mm-hmm. Cooney was like, they didn't have to do that because the complaints were in the amended complaint. So why ratify something that you're already approving to in the amended complaint? How do you feel about that?
Yeah, honestly, what I'm going to say is it doesn't matter how I feel about it. It's going to matter. But I know what you're saying. But really, that's my point is the judge, this is something that the judge really seemed to be very interested in. Very. And again, I'll say again, I really was not interested in this because I thought it was so easily ratified or not remedied. And I haven't, going back to their amended complaints and all of that, it's very interesting to me if the judge determines that yes, they went, it's going to be his call. Did they ratify it or not? If he determines that they didn't ratify, that could be a very quick and easy dismissal which I thought there was no chance of a dismissal happening, maybe a stay, but that is an area where he showed a lot of interest where he possibly could open the door and say, well, this is dismissed, you didn't have standing, you're going to have to refile, and at that point you're going to be behind the state of Florida case. But I don't know how he's going to go on that. Coney made good arguments one way. I thought King made good arguments. And I was surprised at how interested the judge was in that. And then I'll go back to, I think you briefly touched on the sovereign immunity point. Yes. And Coney's argument is the Troy precedents, okay?
Correct. Farmer versus
Troy. And King on his rebuttal went back again and said that does not apply in this case because Florida State, the difference is Florida State did not register as a nonprofit entity in the state of Florida or in the state of North Carolina, and they weren't doing business. I don't know the legalities of that and why that is such a big deal, but that was another thing that the judge seemed to be interested in. So I think those couple of points, the other thing that I talked about, and then the sovereign immunity, whether or not Farmer versus Troy is the appropriate precedent for the judge to consider.
And I agree. And I felt like with the sovereign immunity piece, again, I didn't think the body language of the judge was giving me warm and fuzzies for King's argument with that. However, he did, again, take those notes once King was done as if there's something he needs to check on there. I don't know what that something is. The body language to me was like, there's not much happening, but there was something
Maybe he wants to go back and read that case and look at the footnotes. I think they talked about the appellate court footnotes and different things like that. So
well, let's get to the motion to seal. You ready? We good to move on?
Yes, definitely.
Motion to seal. So Stone who I said I wasn't sure if she was an ACC or an ESPN attorney. She's an ACC attorney. Yep. Korn was the ESPN attorney. He actually didn't have a whole lot to say. It was mainly ACC.
He kind of put his hands up and was like, "Yeah, this is pretty simple, easy."
This is, and that's the first thing I have written down for him. Yeah. This is an easy decision. But let's start with Stone, the ACC attorney. Again, this is the motion to seal the ESPN agreements. She stated that there has never been a single instance where these types of contracts have been produced in a public records request. These are not viewed as public records in any state, and if they were, we would then go to the issue of trade secrets. However, we don't even think we have to cross the bridge of trade secrets because these aren't accessible through a public rights request or public records request. The judge then said, why don't I have to decide this? Why don't I have to? And she said, because release would cause greater harm to the parties of the contract than it would to non-disclosure to the public. And I found that really interesting. I don't know if that's the threshold here or not. I have no idea. But if it was, I found that as a strong statement from her. Maybe.
It calls for the judge to make a judgment call
for sure.
Which one he believes.
Korn, and that was, she talked a lot. But just not a ton of substance.
Korn, I think, made a much better argument than her.
And he was quick.
Yes.
So he stands up, and he was a young guy, too, from what I can tell.
But he was confident.
Yeah, confident. Korn stands up. He's the ESPN attorney. He goes, Judge, this is an easy decision. Harm will be incurred if there is no seal. These have been disclosed in discovery with protective orders in the past and have never been determined to be public records. Lastly, he wanted to reaffirm that these are trade secrets. So they're kind of giving that as the second out, this whole trade secret thing. But they are hanging their hats on these are not public records. And if you're there's nothing wrong with having them disclosed in discovery as long as they're requested with protective acts. And they get into that a little bit more too.
I really think that the ACC lawyer, I was not too impressed with her arguments because, again, she's just throwing it up there as a judgment call, saying that, it would harm us more than it would harm the public. Well, that's up for the judge to consider, whereas the ESPN lawyer, Korn, now you could be confident when you got Disney behind you, all that Disney money, but he basically said the threshold here is if you release today, will we have some kind of injury? Yes, we will. So it should be sealed for now, and you can rule on it later.
Absolutely.
The other portion.
Which is, well, I'll get to what I think about this towards the end. So Lamb is the FSU attorney. He then stood up. He didn't do much for me. I'll be honest with you. I did this whole motion to seal. The attorneys on this, the two guys, the King and Cooney for the motion to dismiss and stay, I thought did really good. I thought the attorneys, other than Korn, he was just like, hey, here's what it is.
Yeah, kept it simple.
He threw it out on the table and was done. The Lamb and Stone, I don't know. They just didn't do much for me. But Lamb goes on here now. This is the FSU attorney. He says it would be improper to seal a public record. They have a burden, they being the ACC and ESPN, have a burden to show what, if any, information should be sealed from the public. The court then must make a determination on that. The ACC ESPN agreement is that the judge should just trust them and that the 13 pages that were enclosed to the judge for this hearing is all that you need to know. He was making this case that, and he meant, I didn't write it down, I think it was like 116 pages or something, like massive document. They only provided 13 pages to the judge, and his argument is, they're just telling you, judge, trust us, we gave you everything that you need to know. They actually replied to that later on, which I found interesting. And again, another smile from the judge as they replied to it. The judge then comes and says, the ACC said that you will get the documents under a proper protective order if it goes forward in North Carolina. Have you sought these documents outside of full public disclosure? ? You will get these documents in a litigation. What am I missing here? Lamb says, we can't waive public record laws. Just hanging their hat basically on the Florida state sunshine laws. I think Lamb lost the judge here. I think he did. That was my read on it.
So what I read on this is I don't know this part. They are fighting it somewhat, but I don't know. I think this is more about setting the stage for their later argument on breach of contract.
Oh, for sure.
Because not only did he mention Florida sunshine laws, again, they brought up the fact that we have 7 public universities in 9 different states that all have different laws about public records. And that basically you can't, in North Carolina, if you do this and you seal this, you could be breaching the laws of other states that say these must be public records. Whereas, again, favorable court in North Carolina, they have a more limited view. Now, this is, again, something I was going to save towards the end, but you and I had a discussion about the Florida sunshine laws versus other states.
Yes.
And Florida sunshine laws, when you look at the writing, they are very similar to other states.
Absolutely.
But what we keep coming back to, and in this case, they wanted it to be in North Carolina, okay? Why is that? Well, these public all of these laws, they have similar laws in the different states, but it's not so much about the text of the law, is how is it interpreted? What's the precedent in each state? Well, in North Carolina, it's been the precedent has been that it's been viewed with a very narrow, maybe more business friendly approach. Whereas in Florida, there is a lot of precedent about sunshine laws. So people have won those cases over and over again. If they're in Florida, the precedents are, if there's any information about public taxpayer funds, whatever, they lose every time. And that information is disclosed to the public. So I really think that his name was Lamb. I don't know if he really was successful in his argument as far as keeping them sealed right now, which I think is your point.
Yes.
But I really think he was laying the foundation for that later argument of we didn't breach our obligations because these cannot be sealed. These cannot be private because of the state laws in Florida and some of the other states. And so I think they're kind of setting the stage for that later on.
I agree. It was definitely a stage set. 100%. I think it was a poor argument to seal right now. I shouldn't say poor. It was a weak argument to seal right now, but it certainly seemed as he was talking, he was setting something up for the future. I totally agree.
And the judge's perspective seemed to be like, well, why can't we just keep them sealed now, until we determine later that other argument? And Florida State didn't really have a good argument against that, other than the fact that, well, hey, you just can't do it because you're breaking
our public sunshine laws
in other states, including Florida.
Exactly.
So we'll see how what the judge thinks on that.
So it went back to Stone, and this is the part on our last episode I went, what the heck was this? And I got to be honest, listening to it, it wasn't nearly as bad as the tweet that I got. I'll be honest with you. And I tried not to get into too much detail, but the tweet, I was going, what is she saying? And hearing it, it was better. It wasn't great.
It wasn't as bad as it looked.
It wasn't as bad as it looked in the tweet. So the judge goes back to Stone and says, why didn't you try to seal this document in Florida? Like, there's the motion here. Why isn't there a motion anywhere else? So she says, FSU made a determination to disclose confidential information during their public meeting after we put them on notice. We now cannot unring the bell in Florida, according to her. Highlighting the allegations in their complaint would cause more harm than good. It would provide confirmation that there's confidential information in their complaint. This is in the filing in Florida. Most of what we see is media speculation right now. We have not yet highlighted what those details actually are. Also, the court has been clear in the past opinions that we have reviewed to only submit pages of a contract that pertain to the allegations and not the entire contract. And that got a smile from the judge. So 2 different things here. The first one is she's answering the question about why didn't you do this in Florida? She's basically saying, the tweet was just like, we don't want to bring more attention to it, which is kind of what she's saying. But she's also saying, if we bring this, there's items in, we're going to confirm what's out there, which, okay, I don't know. It's still a little...
I got a strong take on this one. Can I
a little weak. Go for it.
I think she was tap dancing on a big pile of bullshit. Here's the thing. Here, the judge asked, well, why didn't you just seal it in Florida? And she tries to go through this rigmarole. Then we'll just confirm, blah, blah, blah. But really the answer was because they know they'll lose in Florida. They're much likely, they're going to lose that in Florida because of their sunshine laws and because of how they're interpreted and all that. they want to get the precedent, the first decision on this in North Carolina, because North Carolina is a little bit more favorable, has more favorable history and precedent to this argument.
Understand.
So, I didn't think it was quite as bad as the tweet, but as she went on, actually, I thought it got kind of worse and worse. Yeah. Where she's just kind of tapped, and we've seen that in multiple different areas. For all 4 of these lawyers, when there was an area where they didn't have a strong case, they kind of tap dance, and the judge was just peppering them with questions, putting them in a bad spot.
And all of them, at that point, they need to learn the whole less is more, maybe. When you don't have a good argument, don't just talk in circles and tap dance on a pile of shit or whatever you just said.
Tap dancing on a pile of bullshit.
Just be done with it. But anyway, the other piece then, of course, was about, she brought up this whole, where FSU was really hammering them on, you only gave them 13. They just want you to trust them. And it was interesting. Again, another just nice little back and forth with the judge where she says, we've reviewed past opinions of yours, and we've known that you only want people to submit the pages of a contract that apply here, and that's what we did. He looked up and smiled
because he knows.
That's how I roll. So I saw that getting a lot of play in some comments and things that what else are they hiding and It's clear here what they did is what the judge would have asked them to do for now. And this is just a motion to dismiss right now. That's all it is.
And I really think a lot of his little smiles were very knowing smiles. Like, I already know the answer to this. I know why you guys are doing this. It's kind of like when your kid is buttering you up because they want to ask you for something, and he knows what they're doing and why they're doing.
For sure.
I don't think you can read too much. There's a lot of people, that are reading into his, whatever. I read more into his questions than his facial expressions.
I like the smiling.
Yeah, he does. I like him too. Yeah, he's my new second favorite judge behind Judge Levy.
He might be my first.
I don't know.
Levy. I know he's our first. Yeah. You're first. No, I won't go there. So the ending of this now, the judge just ended this stating that he would get a written order out again as quickly as possible, and he said he was pretty confident he'd get it out well before April 9th, which is when the hearing is in Florida. But he did say the motion to seal may not be done at that time. He said, I'll try to get them all done at the same time. He was confident he'll get this dismissal or stay out before the 9th. Not as confident in terms of the motion to seal. So with that, I want to summarize this, and I want to give some conclusions. You ready to roll?
Yep, go for it.
So it was clear to me, again, from a complete outsider, I have no skin in this game, but it was clear to me that Cooney with the ACC just had better articulation. I felt like he had a better argument, and maybe that's just because he was more polished. Again, that whole King starting off with a struggle set a bad tone for me versus Cooney set off, and he was a man on a mission from the beginning. And, just setting that pace early on, I just had a good taste in my mouth from Cooney and not as good from King. So it is what it is. It doesn't mean their arguments are better or worse. It's just the way they articulated things. And so, again, that doesn't mean there's going to be a stay or dismissal or motion to seal or anything like that. I just felt like the ACC won the battle in terms of a better articulation of their position from a verbal standpoint. That, again, doesn't mean that they're going to win. I just thought they did a better job here, specifically Cooney versus King. That was my take. Any take on any of the...
So you're going to make it... What do you think is going to happen?
You want to break into the arguments? Let's break into the arguments. So I'm going to start with motion to seal.
Okay.
I'm going to start with maybe what I would consider the easier ones for me, and then get to the more difficult ones. So let's get into them. Motion to seal, I think this is the easiest one. He's going to seal it for now. There's got to be a protective order. It's going to get... If this gets to litigation, it's going to be in the filings. It's going to be under protective order. That's the way to do it. To me, non-issue, it will be a seal. That's my opinion. You have anything on that?
I want to wait.
You're going to wait? All right. Well, the next one is ripeness. Again, was there an actual controversy? To me, ACC wins this one almost hands down. I don't think there's much here. Again, that was why FSU brought this up third. I think it is their weakest argument. It's why the ACC started with this. They know it's FSU's weakest argument. This is a non-issue for me. ACC wins this argument, again, hands down. So 2-0 right now for the ACC. Let's get into sovereign immunity. Not as cut and dry for me, Steve, but I am going to make a conclusion on this. I think the judge will rule, if there's a ruling, I don't know what you call it, I'm not a lawyer, but I think the conclusion, at least for the judge here, will be on the side of the ACC. I think the Farmer-Troy arguments, what was the other lawsuits that were brought up by Cooney, I just felt like he had a stronger argument to make, and it just didn't. It sat better with the judge. Their brief and their argument sat better with me than what than FSU was bringing and what King was bringing on sovereign immunity. And as I said before, I think the judge knows that this really should. I got this feeling that the judge knows this should be heard in North Carolina. I don't know if you agree with me. I just kind of got that feeling, like whether or not this dismissal happens and they have to submit their claims, that may be. But I think he thinks that some of this has to be heard in North Carolina. So sovereign immunity, again, 3-0, ACC. That's where I'm going, 3-0. Now let's get to the beefiest ones for me, standing, and we're gonna make two of them, right? Materiality and ratification. We talked about both of them. This is where the judge really dug into both sides on this, and this one's way harder for me. Way harder for me. I'm going to start with ratification first, because that's really ACC's backup plan if they fail on materiality. Yeah. This one's, again, these are tough for me. I'm actually going to say, I think on the ratification piece, I could see him having this be a stay. Just because I don't think there's enough there to dismiss it. I think both sides made decent arguments-ish. I'm not sure I'm one way or another on that with the ratification piece. But it only gets to ratification if if materiality fails. So let's get to materiality. Again, I'm going to say there's a stay here for materiality. If I had to pick, if somebody said, you've got to pick one side or the other, JY, I'm going to pick ACC on materiality. I am. I think the Cooney made a good argument that you need to let the bylaws rule and the ACC govern themselves. This isn't your place to get involved here. Because when it came back to King, he didn't even touch on materiality. He went strictly to they didn't have a vote. Yeah. And that was harsh for me. Like, the judge was talking more about materiality, and King didn't get back to that. He said, well, they didn't have a vote, which to me was a slip up for King. Like, the judge wanted to hear him about materiality, and he went straight to the vote, which is a standing piece. Yeah. But they're parsing this between a materiality of litigation and ratification. So if I had to pick here, I'd be picking ACC, Steve. That's where I'm at. What do you think?
Okay, so
but overall, he's going to stay.
Okay,
that's my opinion.
All right. So overall, I think it's important. There are as far as the motion to dismiss and the motion to stay, that is the basically the plaintiff, the party making those motions is Florida State.
Correct. Yes.
Whereas the motion to seal is ESPN. with ACC in agreement.
Correct.
Okay. So I'm going to go in reverse order. I'm going to start with standing.
Oh my gosh.
Yes. So for standing, now here's the thing, and you made mention how the FSU lawyer kind of skipped over the materiality point, and I'll just bring up again, I really think, I think that their main argument as to why this should be dismissed, basically they're saying this should be dismissed, not just stayed, but dismissed, because of that ratification issue, because of the vote, that the vote wasn't taken before, and in their eyes, they're making the argument that they didn't ratify it. And they're putting all their eggs in that basket. And to be fair, the judge, when he came back, he said, you can talk about anything you want, any of the other issues, but I really want you to talk about this ratification issue. I want to know. So for me, I'm not going to make as many definitive conclusions for you, but what I'll say with this is I think they could go either way, because I actually think on the vote issue, I'm coming around to maybe Florida State has a better argument on that when I used to dismiss that. The materiality, I think the ACC has the stronger case on that part, and that's why they're focusing on that part. So I'm gonna kind of just leave that part up to a tie. However, I will say I think that after hearing these arguments, I think that before I said there could be a stay, but there's no way it was going to get dismissed. Yeah. I think after hearing these arguments, Florida State actually has maybe a better chance than I thought of just getting it dismissed. The judge dismissing it and saying you have to refile. I think that's more of a possibility, where before I thought there was no possibility of that. The materiality, that could lead to a stay. We'll see. But I think the ACC had the better argument on that. Sovereign immunity, I think this is an area that could produce a stay.
Okay.
I think it's going to come down to, for the judge, he has to make that determination of, obviously, the ACC lawyers, they know North Carolina law, they know the precedents. We had the one case, the Troy versus Farmer versus Troy, and that comes down to the argument of, should we apply this case? Is it the appropriate precedent? Right. I don't know how the judge is going to go on that, but I think that area could lead to a stay. As far as ripeness, I agree with you. I think that the ACC won that argument. You know, it's obvious. It's pretty obvious. I know some of our Florida State fans are going to be mad at me for saying this, mad at us, but it's pretty obvious on the ripeness of the case. I thought some of the arguments, the rush to the court and all those things, it was obvious what Florida State was doing. They put it out on the internet. They were obvious. They were broadcasting it. That ripeness argument, I don't think is going to be a winner for Florida State. I see the ACC winning on that area. And then the motion to seal. What I'll say on this is, if the case moves forward, if it's not dismissed, even if it's stayed, but it's moving forward and it's still an active case, I think the judge is definitely going to seal for now until he makes a further ruling later on the issue of the public sunshine laws in the state of Florida and the state of North Carolina and the other states. So for me, the motion to seal is the easiest one. Yeah. If they move forward, I think the judge will definitely seal for now.
Yes.
And the arguments made by Florida State, I don't think were super great of why can't we just seal it for now and then unseal it later if we make another determination.
And that's an important part. Like, it could be sealing it for now. That doesn't mean it's sealed forever. That doesn't mean it's not part of discovery with protective orders. That doesn't mean any of that. It just means it's sealed for now. And that's really, really important. I think some people think this is the end-all, be-all. I would also say the sovereign immunity piece, I think, is the easiest stay for this judge. If he wants an out, which I didn't get the feeling that he's looking for an out. I think he wants to make a legit ruling on this. But I think if he wants an out, a stay on the sovereign immunity piece is the easiest out he can take.
And so that leads to me, I'm going to make one final point. I still think we are closer and closer to the potential of having dueling court cases in different states. There's been this assumption because of other precedents that, we're going to pick one and we're going to go there first. Okay. Well, I think a lot of the laws made by the ACC a lot of the arguments are they want North Carolina law and the precedents set in North Carolina to be interpreted on this case, and they want this case to be determined that way. And this judge, he said again, this is my colleague in the business court, made this ruling.
Yes.
Why am I going to disagree with him? The appellate court and the Supreme Court has upheld these other rulings. Why am I going to disagree with them? They're the people. He said they judge my papers. They grade my papers.
Yes, he did.
Yes. So I think it could set up a situation. He may stay it, like you said, and kind of punt. I think there's a possibility he could dismiss it. Or I think if he continues with the case, I think we may see dueling cases, because I could see the Florida State judges saying, no, they're interpreting these laws incorrectly, these laws that are in Florida, state of Florida, and these should be interpreted in a certain way that apply to Florida State University, a public university in our state. So we may see two court cases going on at the same time.
I agree. I'm going to say, in my opinion, the only way this gets dismissed is if he doesn't agree with the way the ACC deemed the whole materiality issue. I don't think it's a ratification thing. I don't think it's a sovereign immunity thing. I think they're stay worthy. I think the only way he gets to a dismissal is actually on materiality for me, because he's gonna have a different judgment than the ACC did on what materiality actually means. That's my opinion. The last thing I want to point out is priority didn't even really come up. No. That was like, the judge kind of said they have priority. You've got to make arguments why priority should be overruled. Right. What are the other arguments, which is materiality and ratification. Right. That's why we're focused on that. But the priority thing, the rush to the courthouse, not an issue for this judge whatsoever. Yep. So with that, hey, I know you mentioned we might upset some FSU fans. We're not really here to powder their bums, so to speak. No. We're here to give it as it is. And we've had plenty of comments that people appreciate our unbiased opinions, and that's all they are. They're just our opinions. We love your comments. We love you disagreeing respectfully with us, and we totally get that. And Jen, what was her name? Jen from the Renegades. Santi, if you heard this, we'd love to have you on if you're interested. Watch some of your guys' stuff. You do a great job as well. Appreciate you guys have Doug on there. I think he does a good job following this. He does actually one of the best jobs following all this, quite frankly. You know, he's got some seminal color glasses every while, but I appreciate the coverage. So, hey, with that, we thank you guys for watching. Give this sucker a like. Subscribe if you like our content. We'll see you next time on the Big Mountain.